Robert says, are you gonna? Am I gonna cue you?
He said that you were going to tell what we're doing today, and then okay. I was making sure.
She's all sure.
Okay, everybody. So today we're going to start on the first of our teaching presentations that are on the research topics that y'all picked, and the group that's going to do search and seizure is starting. Please engage in discussion the way you always do when you're invited to. We just don't want to all talk at the same time. I don't know who's up first up there, but I'm going to turn it over to you and let you get started.
Okay. I'm Robin McCann.
I am Yvette Madrid.
Amanda Brown.
And we're going to present today the search and seizure in schools or in public schools. Before we get started with our presentation, if you would open your folder and pull out the school search case study that is in the side folder. And if someone would volunteer, could you please read that out loud for us? Could I have someone please volunteer? It's a short little case. Thank you, Megan.
A junior contacted the high school vice principal to report that another junior student, Michael Slattery, was selling marijuana in the school parking lot. The vice principal had received reports that Slattery was involved with drugs before from a senior who had provided the vice principal with reliable information about illegal activities of another student in the past. The vice principal then called Slattery into his office and asked him to empty his pockets. Slattery was carrying $230 cash in small bills and a piece of paper with a telephone pager number on it. The vice principal knew that drug dealers often use pagers. The vice principal called the school security, who searched Slattery's locker but found nothing. When the vice principal told Slattery they would have to search his car, which was parked in the school lot, Slattery refused. After speaking to Slattery's mother by phone, Slattery turned over the keys. The school officials found a pager and a notebook inside the car. The notebook had names with dollar amounts written next to the names. They opened the locked trunk of the car and found a locked briefcase. Slattery first said that he didn't know who owned the briefcase. Then he said a friend owned it and that he did not know the combination. The school security officers pried it open and discovered 80.2 grams of marijuana. Police were called and Slattery was arrested.
Thank you very much, Megan. I was going to put this on the PowerPoint, but we went ahead and made a copy for you because we want you to have this with you. And as we present the search and seizure today, keep this case in the back of your mind because we're going to come back to it at the end of class. And I want you to try, as we're going through, to decide if you think these searches that took place in this case were constitutional. And maybe by the end of this presentation, you'll even be able to tell me some of the reasons that the case was constitutional. So this is just something for you to have and to look back at as we're going through. And at the end, after we presented the information, we'll see if you can answer the questions to it. I wanted to do that first. So you have that there. And if you need to reflect back to it as the presentation's going on, you have it there. Okay? Starting our presentation now. Search and seizures in the schools or the public schools.
Press felt the penny.
Press what?
Like what's selected, felt the penny, just press that again.
Go to arrow. Oh, my bad.
Now just
Gotcha. Thank you. Okay. All right. We first want to start with the Fourth Amendment. If somebody would please volunteer, could you please read us what the Fourth Amendment reads? Anybody? Any volunteers?
I will.
Thank you.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Thank you, Lindsay. Very good. Okay, Fourth Amendment, and we're going to break it down a little bit to help you understand what this amendment means. From reading this Fourth Amendment, who does the Fourth Amendment protect? Okay, the citizens or the right of the people. The people. Very good. Okay. Second question: what does the Fourth Amendment protect? There's four things.
Persons, houses, papers, and effects.
Very good. Persons, houses, papers, and effects. Of those four, is there any of those four things that you're not clear on? Could somebody give me an example of what you're considered your persons? What is something that might be considered a person?
Like on your body?
Very good.
Search on your body.
Very good. Okay, would your wallet be considered as a person? Something on your body, very good. Your clothes. A good question. What about a bodily fluid? Blood or something like that?
Yes.
Yes, very good. It is. Okay, it is considered under person. Okay, houses. Does anybody have any questions on houses? Okay, your front porch does count as your house, and if you have a little building out back, those kind of things do count under where your houses are. Okay, papers is a diary paper.
Yeah.
Okay, good. Last one, effects. Anybody have any idea what might fall under effects?
Anything that's not what other ones.
Okay, something you might have right now.
Like
Okay,
small personal property, like purses.
very good. Purses, the backpacks, those kind of things. Very good. Okay. Right now in this class, what does the Fourth Amendment mean to you? Just asking, what does the Fourth Amendment mean to you? As you sit in this class, you have your effects. You have your personal belongings. Okay? So look at the things you have right now, your personal belongings. Something to yours, and everybody just kind of raise up one thing.
How about my jump drive?
Your perfect. Jump drive's awesome. Okay? Think about these questions as we go through today. Okay? What right do you have to keep what you just held in the air private? Okay? Does it change depending on where you are? If you're at home, if you're at school, in a courtroom, on an airplane, does it change depending, the privacy change depending where you are? Okay? The next question, does it change depending on what it is that you're trying to keep private? Okay? Does it matter? I mean, does it depend, does it change depending on how important it is? Okay? That's the question and the challenge of the Fourth Amendment.
The next thing we're going to look at is what exactly is a search. Some examples are examining private items or places that are not open and exposed to public view. This could be something like a locker. Physically examining or patting down a student's body or clothing. This includes the student's pockets. Opening and inspecting personal possessions. This is something like a purse or a book bag. Handling or feeling any closed or opaque item. Opaque means you can't see through it, so this could be something like a book. Using extraordinary means. This means you can enlarge the view or hearing into closed or locker areas. A good example of this is using a fiber optic cable to go in and look inside a closed locker.
Not bad.
Next, we're going to look at what is not a search. Observing an object in plain view. This is something that's exposed to the public. Can everyone point to something that's in plain view right now? Exactly. I see everyone got that one right. Examining an object after a student denies ownership. So there's a book bag in the room. Oh, no, that's not mine. Well, then you can look in that, and that's not considered a search. Examine an object abandoned. One of my favorite examples is when the students come back from a trip and maybe they leave something in the room like a purse, and you go in to look and see whose purse it is to give it back to them. Detecting anything openly exposed to the senses, sight, smell, hearing. Like for instance, if a teacher goes into a bathroom and sees smoke, and so they see the smoke and then they can look for the cigarette. That's not considered a search. Using extraordinary means, this is to enhance sensory perceptions like using flashlights in a room, binoculars, dogs, thermal imaging. These are not considered searches. Okay, next is what is a seizure? This is actually taking something that you've gotten from the search. It could be a tangible object like a pack of cigarettes, a cell phone, anything that's against the school policy that you're taking.
Okay, now we're going to talk about general rules for student searches. You might want to keep these in mind also whenever we refer back to the case. Students have a constitutional right to be protected from unreasonable searches. Students have a lower expectation of privacy at school rather than when in public. I think it was Robin or Amanda that was saying, do your rights change whenever you're on school campus from when you are off campus? And that also has to deal with, too, like school officials have every right to provide a safe environment for the students. So as long as you're on school campus, they have every right to search you, and every school has different policies also. And under the Fourth Amendment, school officials do not need a probable cause to initiate a search. What that means is that they don't need a police officer to search you. Because if you're off campus and say you're out and about somewhere and a cop stops you, that's a probable cause. Okay? And this does not apply to private schools because private schools are not owned by the state, public schools are. Okay? And searches must be based on reasonable suspicion when conducted by a school official or a resource officer, which means if you smell smoke or if a kid goes up to another student, shows them a knife, and is like, hey, look what I got, you know, that's reasonable suspicion. So, next. As I was just saying, a reasonable suspicion is a person initiating a search has well-founded suspicion, objective facts, to be stated upon criminal activity, like I said, when a kid shows a knife or the smoke, and also, too, if they are breaking the school rule.
Next, there's a two-part test for student searches. Student searches by school officials and school safety officers on public property, school buses, and at school events are justified if both parts of the following tests are met. Search justified in an exception and reasonable in scope, and we're about to go further into detail with that.
Okay, first we're going to talk about justified at its inception, which is a search where the search will reveal evidence of a crime, some kind of criminal activity, or it will break a school or violate a school rule. Okay? And what we're going to do now is I'm going to give you, if these four people could be one group, these four, these five maybe, I'm going to give you a little case. Just pull some things from cases. I want you to read your case over with your group, and we're going to decide if it is justified at its inception, if you think your scenario or your case is justified at inception, or if you think it is not justified. You're going to discuss it with the people in your group. We'll give you about a minute, minute and a half. They're kind of short. And then we're going to come back. I'll have somebody to read the case out loud. If you go ahead and have somebody ready to do that. And we'll go ahead and try to see if it's justified, not justified, and if we can see what the reasons why are. Okay? All right. Yes. No. I'll read it. Sure. Okay? Group 2, if you don't want to read your case, I'll read it. It was, when we were doing our research, this case came up a lot. I mean, it was like on just about everything we pulled up, and we decided to put it in there. But if nobody wants to read it, I'll be glad to read it. We're going to, I was just kidding, we're going to do the first one. Who has case one? Would you read it, please?
A search of the defendant and his locker took place. The search was based on direct statements from 2 students to a teacher that the defendant had shown them a gun he had brought to school as a result of a fight a few days earlier. The school official had prior knowledge of the fight, and the teacher informant, a longtime employee of the school, considered the student informants to be reliable.
Okay. Justified at inception, not justified.
He said justified.
Very good. Everybody agree? Okay, justified at inception. Okay, now case number 2.
Can I ask a question?
Yes, ma'am.
What makes it justified?
Sorry.
We decided it was justified because it's evidence of a crime that was about to happen. The fact that he brought a gun is a school rule violation, and it puts other students in harm's way. So
Very good.
it's justified.
Okay, case 2.
Cornfield versus Consolidated High School School District. The defendant, a public high school student, was subjected to a nude search based on an unusual bulge in his crotch area. There were various allegations that the student had, on previous occasions, allegedly smoked marijuana on a school bus, hid marijuana in his crotch area, dealt drugs, tested positive for marijuana, and failed to successfully complete a drug rehab program.
Okay, justified, not justified.
We said justified.
And do you know
Because-
reasons?
The history of
Yes.
his doing it before, history of previous.
And it's against the rules, and it's a crime to have drugs.
Good.
Illegal drugs.
I could inject something related here. When I was high school teaching, down in the dressing room, we had a fan that drew in air to the dressing room from the outside, very large one. And I was standing near that fan inside the dressing room one day and suddenly got this smell coming into the dressing room that I thought, this smells like marijuana. And a colleague and I went outside, and the students were standing right there, one of them smoking marijuana, hiding in a little protected area where the fan was located. And upon seeing us arrive, the student took off running, you know. We told the assistant principal, who was in charge of discipline, about this right away. He was able to locate the student, took him in, and where was the marijuana at this time? Yes, same location, stuck down inside his briefs. And so he thought that it was also justified because he had a reliable source reporting that he had previously been seen doing that on campus. So it happens.
And like I said, that came in all the research, that case was somewhere in just about everything that I read also. Okay, case number 3.
This is a student was searched after who was seen in the parking lot of a high school attempting to avoid detection by ducking behind a car, and who gave a false name when stopped by the school security guard.
Okay, justified or not justified?
We said not justified.
Very good. Why?
Because
They didn't do anything.
Exactly. Was there any evidence of a crime? No. Was there anything that he done to break a school rule?
unless he's
Really?
skipping out of class, but
Right.
that's not for nothing
Right.
research.
Okay, good. Not justified. Very good. Okay. That's justified its inception. That's the number 1 on the test. Now going to the number 2 on our test. It is reasonable in scope. Okay, when it's reasonable in scope, it is reasonably related in scope to the circumstances that justify the initial suspicion. Okay, it has to be reasonably related to the objectives of the search. Okay, and it cannot be excessively intrusive given the type of infraction, the age, and the gender of the student. Okay, you can't intrude the person too much because you got to consider the type of infraction or the search that you may have to do and the age and the gender of the student. Okay, so you need to think about those things too. Okay, same thing again. We'll give you 3 scenarios. Come up with whether you think they are reasonable in scope or unreasonable in scope. And please have somebody ready to read. Got about a minute.
I think it's real. Because she has to
I don't think that's just good evidence.
It wasn't like she was just going through. The reasonable related to the search means that say I thought you had
But what are you searching for? But he hasn't been seen.
or whatever, and they said that you.
So like, what's the point of searching?
But
You already found
she
it.
searched for all that.
And if y'all don't agree, present both sides.
Happened to found. I mean, it
Let's
was.
say you don't agree on this.
But you find, if one thing was lighter in his hand, then maybe you.
Okay, everybody ready? Okay, case number 1.
The search of public middle school students' pockets for cigarettes after the student admitted he had been smoking. We said that this was reasonable because it was not excessive. He'd already admitted to smoking, so we were just looking to find those cigarettes in his pockets.
Right, very good. Because of his admission, it was considered a reasonable in scope. Okay, number 2.
After a teacher saw cigarettes in a student's hand, his locker was searched.
Reasonable, unreasonable.
What is it?
I said unreasonable because what are you searching for? If you already found the cigarettes and there's no reason for further search.
Well, there could be.
And I say reasonable.
Had the cigarettes, there could be something else, so he does have every right to search
Further.
further.
But does he have a reason to
Now-
believe that they're being in?
Now, if he did have the cigarettes and they just wanted to search him, that's not reasonable at all.
Right.
You know, but he obviously had the cigarettes in his hand, so they were like, okay, what else do you got? You know, so,
So you're not looking for additional cigarettes, you're looking for something else?
a lot of the times.
You want to look for what, they found cigarettes, you want to look for the cigarettes. If you come across something else, well, that just happens by chance. As far as the locker goes, well, did they have a reason to believe that there would have been cigarettes in the locker? But
Isn't
also,
that the unreasonable
The reason
part,
I
though?
brought that up, yes, it's related to what she's saying here now, is it says related in scope to the circumstances that justified the initial suspicion. And if that was cigarettes, then you would have to say pretty much that you were looking for additional cigarettes.
Right.
And then if you found something else, you're okay. But if you say you're looking for something else, that could be what,
unjust.
right, what would make it not reasonable. Okay.
What's the reason for looking for more cigarettes if you already found cigarettes?
If the student
To
denied it.
deprive them of something else that they're not allowed to have on campus.
So this case was reasonable? It was a reasonable search?
Okay.
3.
Based on information that she or another student had a knife at school, assistant principals searched the student's purse and finding no knife, unzipped a very small pocket inside the purse where marijuana was found.
We said reasonable, and I mean, they searched because the knife, and then she just happened to find the marijuana.
So what?
Go ahead.
I was gonna say, it was the principal who searched?
Assistant
Well, did that principal can the principal look in other smaller pockets of the purse, or does he just have that right to open the bag and look in the open general part?
It's part of the
He
purse.
could ask the student to,
Yeah, but that's like
To empty it,
look-
and if
look
they
how it
refuse
looks.
to, based on the information that they already have, they can go further into the purse.
It says, I mean, it's a pocket in the purse.
Right.
Usually by
Because a
that
knife
point-
could possibly be
By that point,
small enough
somebody
to
else
go
has to get
into
involved
the
inside the school.
zipper
By
part.
that point.
Right.
You know, I mean, this day there's tiny little bitty knives, so I mean, we said reasonable in scope because I think, you know, they have a right, if they're in the purse, they have a right to even go into the small zipper part because of this day and time. I mean, there's real tiny knives or little switchblades that, you know, can fit in a smaller zipper.
Well, and it doesn't say you can only open it so far. I mean,
Right.
It says you can search whatever. So,
Okay, any questions?
The court case I'm about to talk about will
Good
go
job.
more into that, and you guys will understand better.
Y'all did great.
Okay. The case I'm going to talk about is a major, like a landmark case when it comes to search and seizures. In 1980, a teacher at Piscataway High School in New Jersey, I don't know. I say everything. So in New Jersey, found two girls smoking in a restroom. Keep in mind, these girls were only 14 years old, and this was also a violation of the school rules. The teacher caught them. She took them down to the principal's office, who is, actually they ran into Theodore Choplick, which was the assistant principal. One of the girls admitted to smoking, the other one didn't. And while the reason why it is called TLO was because she was 14 years old at the time. Because she was a minor, they couldn't say her name. And so her real name is Tracy Lois Odom. And of course, by the time this came into effect, which is 1985, she was not a minor anymore. So, you know, she denied it. Whatever. He was like, hand over the purse, you know. She was like, what? You know? Well, he ended up searching her, and just because she was smoking and she denied it, and the teacher caught her, he had every right to search. So he also found marijuana, paraphernalia, plastic bags. She had index cards of people's names that owed her money. She had a wad of $1 bills. And it was obvious that she was a drug dealer at 14 years old. Well, by this time, he had called the student's mother into the police station. She was still denying everything. Finally, when she got to the police station, she admitted to everything. So she was charged with a delinquency at this time. The case held in court that a school official may search a student if that official has a reasonable suspicion. So there was reasonable suspicion there because she was caught smoking in the bathroom, and she denied it. And it goes on to talk about more reasonable suspicion that she was also breaking the school rules. She was smoking on campus, which was not supposed to be happening at all. Was it unreasonable under the Fourth Amendment? No, it was not unreasonable under the Fourth Amendment because there was reasonable suspicion, which is obviously lower than a probable cause, but it goes into the Fourth Amendment because of reasonable suspicion. And also, too, the discovery of rolling papers gave rise to reasonable suspicion that she was carrying drugs as well. So, yeah.
Okay, next are some procedures for searching students. The first one we have is to remove the student to a private area. When you are doing this, if there's any way possible, try to get a second person to be there with you, even if you're moving from one area to another. And you need to personally escort that person straight to the place where you're going. You do not need to make any stops. You need to go directly to the office, directly wherever you're going without any kind of stops, okay, or any kind of contacts at all. Okay, the second one, always watch the student's hands. Okay, the student may try to discard what they have. They may try to take it out and use it. You never know. You always want to watch their hands. And never walk in front of the student. You always want to be behind them. okay? You do not want them behind your back, especially if you think they have something in their pockets. So you're watching their hands, and you're usually behind them, taking them directly to wherever they need to go. Okay? Number 3, always have a witness. This just protects the searcher, and it helps to strengthen the case against the student. Okay? Just to have somebody with you. This is for your protection. Plus, to have 2 people against the student, the case of the student, is even better. The third one, have a searcher and a witness of the same gender as the student. Okay? This protects the student's rights, okay, as well as the searcher. It will help you also if this goes to court or anything. Okay? The next one's keep the searches discreet. You want the least amount of embarrassment it can be to the student. And when you're doing this, you only want the searcher, the witnesses, and the student there. And if you have to do a search, you don't have the witnesses there. You do the search with you, the witness, and the student only. Okay, the next one, give the student a chance to surrender the items that is sought. Okay, you give them a chance. You ask them, do you have this? If you do, can you put it out on the table, wherever you are? You give them a chance first to go ahead and to give you what they need to give you. If they don't, you let them know you have reasonable suspicion and that you're fixing to search them, and give them a chance again to do it on their own. Okay? So they do it on their own, they don't do it, you tell them you have reasonable suspicion, you're fixing to search them, and again, give them another chance before the actual search. Okay? You need to seize any illegal items or evidence. If they give you anything, or you do the search and you get something, if it is individual items, they need to be put in separate envelopes. Written on the envelopes, what is in there, who took it, who the witnesses were, anything you can think of and you can remember that might need to go in those envelopes. But each item needs to go in an envelope by itself. Okay? And the last one is a special consideration for weapons, okay? And I think it's a little different in every school. I think it's just important that every school has their own plan in a situation that deals with weapons. But I also think it's very important, if they do have that plan, that the staff, everybody on staff, custodians, cafeteria worker, everybody needs to be familiar with that plan. I mean, it can happen anywhere. It can happen in the cafeteria. It can happen in the hall with the custodians there. Teachers, secretaries, everybody needs to be familiar with that plan so they'll know what to do just in case the weapon arises. Any questions?
Nobody has a weapon,
Okay, who can do the searches? That is the school administrators, that means principal, assistant principals, the school nurse can, the safety reserve officer, and when you do a strip search or a student has to be patted down or frisked, you always have to make sure that someone of the same sex of that student is also in the room, or that they are actually doing the ones patting down. Okay.
Now,
What?
Now, whenever you go to do a search, you want to start with the least intrusive, and then, if necessary, go on to more intrusive measures. You never want to start off by telling someone, okay, go ahead and take off all your clothes. That's just not necessary. So you want to start off with the least intrusive search. So a least intrusive search is abandoned property. Searching property that's in plain view that the student has denied owning. Canine sniff by a trained dog, sniffing dog within limits. You're not going to take the dog up to each student in the room and have them sniff them. That's not what we're talking about here. Metal detectors, everyone goes to the metal detector. It's not as intrusive. Lockers, desks, and contents. When the school policy dictates that lockers are private, it is unconstitutional to search them. So it depends on what the school's policy is. And it's also based on what's written in the student handbook.
I'm going to add something.
Every school these days, though, is going to indicate to you this locker is their property.
I'm going to add something to the canine dogs coming in. When it says within limits, most of the time, the canine dogs just go through the hallways into the lockers while everyone is in the classrooms. Now, depending on the school and what type of search they're doing and what they're looking for, I mean, the dogs could possibly go into the classroom. Like Amanda said, they're not going to go around and sniff each student. What if the student has something on them? That's like a big issue with the whole dog sniffing and who can come in and do what. Also.
But it could move from a least intrusive to a more intrusive
Yeah.
if they had to go do it like an individual person.
Have any of you been in schools when searches have been conducted?
I am.
Yeah. Lockdown, et cetera? Yeah. Commonplace.
Would they use a dog to sniff a person? Because don't they like go nuts when they smell? I mean,
It depends
the
on how
student
to-
be in danger if.
But when they're on lockdown, everyone is in the classrooms and all they're searching is the lockers.
But when you're saying if they came in the classroom,
Oh,
would the
yeah.
students still be in the
That's
classroom?
what she said. It would be a more extreme intrusive search.
If you're asking if the dog goes crazy, it depends on how the dog is trained to react. I've seen some that are trained just to sit down. So it just depends on how that specific dog is trained to react.
But the dog can't sniff the person while the student is still in class. Like they have to take the student out in order to.
Right, that's when you're going back to needing a more discreet search as well.
He could pick it up in the class, but then if he picked it up in the class, I would take it somewhere else.
And I think someone over here was trying to say something.
Yeah, I was just saying that they train dogs to find things different ways. Like they'll sit, they'll maybe do something, maybe bark. Usually they have a specific thing they're training.
Exactly. That's absolutely right. Now we're going to the next step. So we just went over least intrusive. Now we're going over to significant intrusive. Now, when you go to search someone's property, like a cell phone, a backpack, a personal computer, a purse, or a vehicle, we all, even sitting in this class, consider these personal things. So it's a little bit more intrusive than just walking through a metal detector. Patting down a person, doing a full frisk of the student, and we also have a video concerning computers, and this is actually something that's happened recently.
Big brother, creepy uncle.
Messed it up. Somebody help me out here, because I don't.
Go back.
Do that turn around.
You can do it on the screen. Just hit the back.
Just hit the back arrow.
Hit the back.
There we go. All right. There you go.
Where is this?
Pause it until we can get the sound.
Not on mute.
On the bottom.
It's bottom right of the two part on the computer. Well, it's not on, youth over here. It's showing that it, a play, is there a button on here that, this says volume on it.
No, that won't do it. That's not. Oh, there we go.
Come in to help us?
Oh.
Yes.
We would have never looked there. Okay.
Now can you
Now try.
start trying to play? All right, I think we're gonna get it working now. Let's try it.
Accused in a shocking betrayal of
Sorry.
trust. Administrators are accused of spying on students during their most private moments. Eyewitness News reporter Natasha Brown is live in Lower Merion with all the details. Natasha.
Well, Susan, good evening to you. This is a copy of the federal lawsuit. It is quite lengthy and quite detailed, and it's really sparking a lot of debate about a student's right to privacy on a school-issued computer.
That is the camera on our screens.
It's a webcam like this that's now sparked a federal lawsuit that is questioning the boundaries of privacy. The suit filed late Wednesday in Philadelphia federal court alleges that the Lower Merion School District spied on one of its students at home through the school-issued laptop webcam. The lawsuit reads in part, defendants have been spying on the activities of plaintiffs and class members by defendants' indiscriminate use of and ability to remotely activate the webcams. The Harriton High School student Blake Robbins and his parents filed the suit after a school official reprimanded Robbins for inappropriate behavior at home. The suit alleges that the district, quote, cited as evidence a photograph from the webcam embedded in the student's laptop.
It's great that we have laptops, and I understand why they would watch us at school, but at home, I feel like that's our private life, that's our own business.
Students in the district tell us they were made aware of the case Thursday morning in an announcement by school officials.
They said that they didn't take a picture. They said that they didn't invade his privacy.
How would you feel if that happened to you?
I would be mad. I would be really mad. But I'd feel at fault too if I was doing something bad on the computer.
It's prompting serious conversations between parents and their kids. Some parents seem torn by the issue of privacy and the school district protecting its property and its students.
Maybe they're feeling a responsibility, the school is, because they're giving the kids these computers, that they would make sure that they're not being used inappropriately. So it's a really tough call.
Well, right now we are still awaiting an official comment from the Lower Marion School District. Meantime, I wasn't.
Now,
Any comments?
before we take comments, notice something they said about they were looking through the camera while the student was at home and not school. So the searches are authorized at home, at school, but not at the student's home.
I was going to say, if the school wanted to protect their property and make sure that students weren't doing inappropriate activities on the computer, they could have had blocked sites or something like that, not allow them to go to certain websites, activate certain cookies. But the whole webcam, I find that to be inappropriate, especially if you're at home in your own, bedroom. Who knows what else they saw?
Or maybe not be allowed to take them home. I'm shocked that they were allowed to be taken home.
I'm shocked that every student had a laptop.
My question is, it said that they saw him doing inappropriate activity and took a picture. So, I don't know if that means that there was, he was looking up inappropriate things, or they actually saw him through the webcam doing something inappropriate in his room.
They took a picture
of it. And took a picture of it.
The answer has 58 screens that they just watch after school.
That's why they call it.
How did they? Yeah.
That's why they call it Big Brother Creepy Uncle.
This is going to be
looking through. It's just
going
weird.
On more and more. I don't mean the spying necessarily, the use of webcams, but the fact that students will have those laptops that are school issued. I was in a meeting the other day, and somebody told me that I think one entire class at Carver next year will be issued laptops with all of their textbooks, all their textbooks on the computer already loaded. So they're going to let them take it home. They're going to want to use them for homework, etc. And hopefully they've heard this case and won't be trying to use webcams for that. Yeah,
It was recent. It was 2009, 2010.
Yeah, this is very recent.
Now, when we look at how it being extreme, we're talking about strip searches. Now, a strip search, you don't have to ask someone to take everything off. If you ask them just to take one item off, then that could be considered a partial strip search. And it's also important to note that the more clothes they remove, the more intrusive the search is. And it also will be considered when evaluating the constitutional rights of the students to how far into this strip search you went with the student. All right, here's a case involving a strip search of 2 second-grade girls. $7 came up missing. They both pointed at one another. No, it wasn't me, it was her. It was me, it was her. Okay. They got sent to the principal's office. Then they got sent back to the classroom. And in some point in time during that, they had went to the bathroom. Well, they actually strip searched the 2 girls, didn't find the money on them. And what was found was that there was no precedent in Alabama or in the 11th Circuit. Do you know what the 11th Circuit is?
Good job. We're just making sure. I was like,
There's some differences in the Jenkins case we just saw, and then here in the Safford case. Now, in the Safford case, there's actually a school policy that prohibits non-medical, okay? And then there was a statement from a student that had received some over-the-counter medicine that it had came from Safford. And so they saw this as suspicion enough to search Safford. And so what they did is they actually went through Safford's book bag and outer clothing. And when the student, they didn't find anything, and so what they did is they actually made her pull out her underwear to look and see if she had it in her panties. And then they had her pull her bra off to the side and shake it to make sure, and this actually exposed her partially during the search. And what was missing from the suspected facts that pointed to the student was any indication of danger to the student from the power of the drugs or their quantity, and any reason to suppose that the student was carrying pills in her underwear.
This case has gotten a lot of attention since it came out.
So the Supreme Court held that this strip search of the student was unreasonable and violated the Fourth Amendment because there was reason to question the clarity in which the right was established. They were protected from liability through qualified immunity. But this search did violate her Fourth Amendment right. Any questions or comments? Okay, some strategies to deal with a search and a seizure. First one, you want to set a visible, clear, specific search and seizure policy for your school. Okay, you need to come up with a policy, and again, as I mentioned earlier, once you have that policy in place, all staff needs to know what the policy is and how to react in any situation. The second one here, you want to involve the guidance counselor. A lot of people feel that the guidance counselor is an advocate for the students. They're the one person in the school probably that would make sure that the student's best interest is represented. So when they're making this policy, have the counselor there so they can see what would come from the student's point of view also. The next one, written up with assistance of a qualified attorney. Okay, I mean, nothing better than having the true attorney right there while you're trying to write these things up. He can tell you what's wrong, what's right. You can have it right there in paper, legally, what's wrong, what's right, and you can go from there. The next one, when approved, it should be shared with all school employees. So there's no question as to what staff can and cannot do when it comes to searches and seizures. I've already mentioned that. You want to make your staff aware. The last one on this slide, in addition, encourage staff to contact the school resource officer or an administrator when a search needs to occur. Some schools do that, some didn't. I've taught at one where we didn't have to do that, but now that I'm in elementary school, we're required. If it's not something right there at the moment that I think may harm another student, I have to contact my principal and either get the student to her or either have her come to me. I mean, it happened. A student told me a kid had a knife on the bus. I do bus duty. The student told me, I got the kid off, stood him right there with me. The rest of the kids are going in the building. Contacted the principal on the radio. She came down. She took it from there. I told her who the witness was, and she handles all that on her own. Okay? Continue. The next step is to educate the students. I mean, you have to let the students know what school searches are. They have a right to give up anything before they're searched. The searcher has to let you know they have reasonable suspicion and they're fixing to search you and give you another chance again to turn those things over. You just have to educate the students on what a search is and what a seizure is also. Students need to be aware of their rights in a school setting. They need to know that anything that they have on school grounds, purse, bags, iPods, lockers, even their car, can be searched if there's reasonable suspicion that they're violating the law or the school rules. Okay? There was
The lockers was a question earlier, and I meant to say it. There's two ways to go about a locker. If the locker has been stated in the handbook that it is private for the students, it cannot be searched at any time it wants to be. If in the handbook, the school specifically says in there that it is a school property and that it can be searched, they can go in the locker and search it at any time. So it's all really based on what's put in that handbook at the beginning of the year. Okay? Back to, if you take out now your school search case study that we started with at the beginning. We'll sum this up real quick. Okay? Slater, and this one claimed that the search of his official person, his locker, his car, and his locked briefcase were unconstitutional. Okay? Do you think the search was constitutional now that you've got all this information?
Yes.
Do? And what's the reason? Anybody have a reason? A few reasons. Tracy?
They opened his briefcase because he denied that it was his, right? So doesn't that allow them to open it?
Okay.
He was involved in drugs before.
Okay.
And they had previous suspicion because somebody had already reported it once and then once before. So then they had reasonable suspicion to check it again. I don't know.
Okay. That's
It was on school property.
Very
His
good.
car was on school property.
Okay. All right. Here's what the courts decided. Okay. The Court of Appeals ruled that under the school search exception to the warrant requirement, the school doesn't have to have a warrant. This search was legal. The court determined that the search was reasonable based on the two-step test. Okay? It was justified at the start of the search, and the search was reasonable within scope. Any questions, comments about search and seizure?
We're almost done. See this little thing we got? The first page is a checklist for searching students. It tells you like what to do with the student, what to do with the item, if you do find an item, stuff like that. It's just to keep for your own records. And then the second thing, search and seizures in the schools, is basically an outline of everything that we went through today. Keep for your records. And then this very last one is a student search report form. If you ever search a student, you have to document it. Everything from who it was, their grade, their gender, what they had on them, why you thought you had to search them, and stuff like that. So
that's just
an example. Not every document is going to be like that.
What's the most important information to remember as teachers? About search and seizure.
Documentation.
Well, if you document an illegal search, have a witness. Okay, have a witness.
Know what's illegal and constitutional and unconstitutional?
Pardon?
Know what's constitutional and unconstitutional as far as what you can and cannot search.
All right. And the idea of it being doing a least intrusive search first, getting permission from the student. I'm telling you, you're going to have opportunities if you stay in education to be tested in this area. If you're in physical education or in athletics, there will be incidents where students will come and say, I had this good jewelry and I left it in my locker, but it's gone. I left my wallet in my locker, but it's gone. Or I left it in my pants and I'm not sure if I remember to lock my pants up, but they're gone and my wallet was in it. You know? And then you're having to decide, okay, what do I do? And where some of the people in these cases are getting into trouble is they're not considering what's least intrusive. They're not considering getting permission. Sometimes they're not going to administrators first. They are initiating on their own searches which are quite intrusive. One of the cases that I remember hearing so much about was a strip search for a very small of elementary school students, a whole class of them, for a very small amount of money that was missing from candy sales or something like that. Okay, so you have to make decisions here about whether or not a search is even warranted, or is this so small that we're just not going to do it. I can remember incidences where we had This was in a girls' locker room. We had them come to us with all their belongings without telling them why, so that they wouldn't think about doing something else with them, with their belongings. And then we asked them to set everything down right where they were, and we asked them, small group at a time, to dump out their purses. And we told them that this was because, that we were asking them to dump out their purses because we needed to look for missing jewelry. And this was something that had been handed down through the family, and why somebody left expensive jewelry in a locker, I don't know, but that's what was done. It did not yield anything. But the students were asked to dump, you dump it out. We didn't dump it out, you dump it out. And nobody hesitated to do that.
Question. So is it, I mean, we couldn't get a hold of like a handbook or thing. We tried to find one, whatever. Is it to protect us, I guess, as the teacher? Do we need to go to the principal first for them to?
You need to know what your school what your school's policy is.
Mm-hmm.
If they have policies that said a teacher can do it, but it needs to be a same gender teacher,
Mm-hmm.
or a teacher needs to have another teacher or staff person present, or it needs to be an administrator, or if you're going to call, if a strip search is warranted, that's the decision of an administrator who will call the police. So there may be a policy that's established by the school system or by an individual school, and you need to know what the policy is.
I teach elementary school, and my kids are very unorganized, and lots of times they'll say, I can't find my book, or I can't find this folder, and I will go to their cubby and look in their cubby or look in their backpack and find it for them. And I mean, this happens all the time.
And that's an open space that you can see into.
Yeah, well, their backpacks are mesh, but I mean, I'll open them and flip through, because they keep every paper ever given to them in one. They don't throw anything away. And so, is that what if I am looking for a workbook or a permission slip or something, and I find something like that? I mean, I have to turn it in, and
okay, what about that?
What would happen?
They asked you to help them find.
Well, they may not ask me, but I'll find.
And so
lots of times they'll say, I don't have it.
Do you mind if I
mind if I help you look?
Okay.
I'll look in your backpack for you, if that's okay.
But if you're saying, I'm sorry, but if you're saying that the book bags are mesh and the cubbies are in the classroom, I mean, you're still within reason, correct? Because the cubby is the school property.
Except you're not really even trying to do a search for anything that's illegal.
No, that's what
help you find a book.
I'm just trying to.
Well, then that's express.
It's a little bit different. All right, we need to wrap this one up. If y'all will take down your PowerPoint, and I guess you have to get off the mics. Switch gears. All right. 5-minute break, is that what you need?
Yes, ma'am.
Am I teaching you to
It doesn't say you're teaching with that thing. I'm teaching with PE.
Started, kind of raise an interest in what our topic's all about. We're going to give you each, kind of like the last group did, each group a different scenario, and we want you guys to look at those questions on the board. If you were a teacher or coach, would you think these codes are reasonable at your place of employment, and do you think they're constitutional? So read through them amongst yourselves and kind of discuss that question for now. They're on the board, I'm sorry. Oh. Sorry, we put it on the board. Just if you want to skim through that, I know that's a long one.
That would be cool.
No, that's just, do you, from what you know right now, just in general, think that's a reasonable dress code? So what do we think if you're a teacher or a coach so far? Just skimming through it. What do you guys think? What's your group think?
We're kind of divided.
Divided, okay.
Are you going to share what the dress code is?
Ours is the athletic code, and it says in order to enhance
The spirit
of the team. Oh, okay. Prevent adverse public reaction, prevent dissension on teams, and for the general welfare of teams or participants, the following regulations governing dress and grooming for pupils participating in and traveling to and from interscholastic activities are in effect. Whenever eating and not traveling in team uniform, male athletes shall wear a jacket and tie. For males, hair must be cut tapered in the back and on the sides of the head with no hair over the collar. Sideburns must be no lower than the earlobe and trimmed. Males must be clean shaven and not wear beards and mustaches. Females, when not traveling in team uniform, shall wear skirts, no slacks or shorts, and cleanliness and neatness shall be maintained at all times. I think the reason we're divided is because some of us went to schools where this was code, and this was just what we did, and then others of us didn't, and I think this is...
So now as a future teacher, what do you think? Do you think this is a fair?
Well, something special about that is that's an athletic code. That's not for the rest of the student body. That's only for people participating in
So as a coach, do you think that's a fair? As a coach in that case? Megan.
As a coach, I don't agree with it because our girls will travel in warm-ups. We're traveling on a bus. We're traveling in an airplane.
But you're allowed to travel.
You're allowed
it says
to.
if you're not traveling in team uniform.
You have to.
If you're team
if you're
uniform.
going out to dinner, then you have to be dressed.
No, it's on. Females when not traveling in team uniform shall wear skirts.
Like a team uniform to me is their jersey.
Well then
I'm saying like if everybody has like windbreakers that they go like traveling and everybody's got like.
So that was our next question. If would your opinion change if you were an athlete?
No.
Would your opinion differ between coach and athlete in that that's an athletic case or an athletic code?
All right, show of hands, how many people think this is a reasonable expectation for dress code? And how many think this is not a reasonable expectation? Okay, just one.
Okay.
And that's an actual one that we'll visit in one of our cases. So
That's
we'll
what,
get to
what my
hear what
question
they-
is, what if they don't have the money to purchase, I mean, they don't have the funds to purchase those kind of things to travel with that they're requiring
A jacket,
as a family? A jacket, a tie.
And I think honestly, if as far as the male side is concerned, if they want to wear a beard, if they want to wear a beard, if they want to wear their hair how they want to wear it, I believe that they should be able to wear it how they want to wear it. Now, if it gets to a point where it's out of control to where they have like, hair down to their back and stuff, I mean that's a different story. But as far as like clean cut and grooming goes, I believe that's up to the player. I just don't agree with it at all.
Okay. So we're going to talk about some of these cases. Yvette?
Like Robin said, what they can afford,
Right.
whatever. Well, I know like some schools give a collared shirt, a certain color that has like the school symbol and the mascot under, and they wear it with the khakis, which I think is totally fine, but I understand where she's coming from. They can afford
Right. Bentley?
Okay, I disagree with her about the beard stuff.
Okay.
Just because, and I understand that you can look professional and have facial hair, but I think what they're trying to look better and saying like, okay, if you're all scruffy and you haven't shaved in 3 weeks, then obviously like you don't look professional.
Right.
And John Wooden, if anybody knows who that is, he as a coach, he never allowed anybody to have facial hair or even have long hair. He was very specific, and I think that he knew what he was doing, and so I think it's a good idea.
Okay, these are good opinions. Right now, we are going to get into what the law says about certain things. But Andrea, do you want to touch on just maybe a couple brief points? I know you guys had a long one.
I'll just do acceptable bottoms.
Okay.
Ours is the general school code. It says jeans, quote unquote Docker khaki style pants, dress pants, capri length pants, shorts, skirts, and skirts are acceptable with the following conditions. All bottoms must be securely fastened around the waist. Their size appropriate, worn with a belt if they have belt loops. Shorts, skirts, and skirts must be at knee length when standing, so should not be higher than 2 inches above the knee. Are not so long as to drag on the floor and do not have holes or rips.
Okay. Do you guys, for a general dress code, is that acceptable or constitutional? Do you believe?
Yeah.
I think so for school because, you know, otherwise if the shorts are too short, it distracts from learning and, you know.
As a student, do you agree? If you were the student and these were
I
your
mean,
rules?
I never had a problem with it, so yeah, I would agree with that.
Okay. Was there a question on this side? I saw a hand go up earlier. I missed. Okay. And you guys, if
Ours
you
was kind of
just
like hair.
hair,
We
okay.
kind of voiced our opinion.
Okay. Yeah, yours. Okay.
So we don't know what that one is?
It's grooming.
It said it was a general school code, and it's not just athletics, but for
This
the,
is the
the
general
boys
grooming.
had to. It says hair may be black, but is not to hang over the ears or the top of the collar of the standard dress shirt. It must not obstruct vision, and it can't be put in a ponytail, a bun, or a comb or a strap. So, and it just said cleanliness of body and clothing is expected of students at all times.
And did you all agree with that? I know you commented on this.
As an elementary
grooming
school, if that was an elementary school, lots of times some of my kids come to school and they haven't bathed, and you know their hair is really oily.
Sometimes I can't help that.
But I know that's what I'm saying. Like
Yeah.
I don't know if you can put that as
Yeah.
as part of the school code.
So maybe
because
in a
they're still young
like
enough
younger
to where
school.
they can't. I mean, some of them do it themselves, but lots of them can't help it. So
Okay.
And the vision thing sounds like maybe a safety issue. They need to be able to see where they're going. So I would think that's reasonable.
right.
But
Okay.
not being able,
Not
what
for
is
their
it,
hair.
not pulling your hair back, they can't pull their hair back?
Uh-huh.
I don't think that's reasonable, because
It can't be long, and if it is long,
start
it can't be
sweating,
long.
you wanna pull your hair off of you, you know?
Well, it's for boys.
This is for
That's for
Oh, I
boys.
didn't hear that.
It's pretty much saying that boys can't have hair long enough to even be pulled back.
And what decision did that group make on that being reasonable?
Kind of what.
We didn't really think that was too reasonable.
Not for the whole school, like athletics, theirs is a little different maybe, but for the whole school, I don't think you can really tell people how to wear their hair.
Okay.
So we'll revisit
Thank you for
those.
you guys' opinions. That was a good.
Okay, so just some background information, we're going to go over some of the laws that are applicable. The first is the First Amendment. We're all pretty familiar with this, but just to recap, it prohibits the making of any law that respecting an establishment of religion or the expression of that religion, infringing on the freedom of speech, the freedom of the press, the right to peaceably assemble, and the banning of petition for a governmental redress of grievances. So the ones that we're going to be dealing with most in our presentation today are freedom of speech. And then we thought that this was kind of a clever picture because obviously it's for everyone.
Okay. And then we get to the 14th Amendment. That's also a large claim that's brought up in a lot of these cases when someone files suit against a dress code or says it's unconstitutional. They pull the 14th Amendment card, if you will. The 14th Amendment stemmed from the Civil War, obviously, the end of the Civil War, the emancipation of slaves, defining now what an actual citizen means. To be a citizen of the United States, you either have to be born or naturalized, which means if you're an immigrant, you have to go through all those processes. And naturalization being that all the individuals who were previously slaves now became citizens. So their freedom, their emancipation. It also states that a citizen has privileges, immunities, rights to life, liberty, and property. And then all these rights cannot be taken away without due process of the law. So a government official can't just come and take all your stuff with no, no trial, no type of anything to let you defend yourself, even if you've committed some kind of crime. The government may not deny you equal protection under the law, which is I'll get into both of those, due process and equal protection. And then the rest of the 14th Amendment dealt with other Civil War issues about reparations and monetary damages for the war and stuff. All right, due process. Due process talks about your fundamental rights. It covers that states can regulate under narrowly defined circumstances. So if your school or your state school board has a rule or dress code, if it's narrowly defined, it's within their rights to say, like they can say that. Their code will hold up. It's not, you can't claim due process if it's narrowly stated. And then obviously you're entitled to the whole procedurals of going to a hearing before you get rights revoked. And I thought this was interesting. It says even expulsion from school, and that's what we'll obviously see. When you don't meet the dress codes, suspension is going to be your punishment. So that's a lot what the plaintiffs are going to claim. And then equal protection clause under the 14th Amendment obviously started out in this back when blacks and white were still segregated. So they tried to say, okay, we're going to make it separate but equal, which in saying, okay, if there's a facility down the road where only whites are allowed, then there has to be the same type of facility in another place where blacks are allowed to go. So that didn't work, obviously. People, it finally got back to the court saying, yeah, it's definitely not fair. They're saying, it's all well and good, it's a good thought, but it's not really happening. And so then you get into the whole desegregation of schools, busing black students to white schools to mix and match. And then today it's become more of we're seeing issues now with homosexual rights, abortion issues. Does a female have a right to her own body? Is that equal if they're saying she can't, make the decision to abort a fetus and whatnot? And it also touches on, like with our athletic code, the group and team camaraderie. Team membership, you can't be treated differently just because of what kind of group you're involved with. Okay, so our first case. This case doesn't necessarily have to do with dress code or grooming, but it set a large precedent for determining what is constitutional. U.S. versus O'Brien, obviously, they considered it a crime to burn your draft card. That's obviously a pretty big deal. If they said, here you go, you're going to war now, and then they burn it. That was obviously a large government issue. What the precedent set was referred to now as the O'Brien test. And so when cases would refer back to it, they would look at these 4 points and say, is the dress code authorized under state law? Does it advance an important government interest? Is it not related to the suppression of free expression? And only incidentally does it restrict free expression. So a lot of our cases, or a lot of these dress code cases refer back to the O'Brien test and is it constitutional? Under these four, and these 4 things will come up and be said in different ways throughout this presentation. So our first large case that has made quite a point is the Tinker versus Des Moines Independent Community School District. And it was in 1965. 3 students, their parents got together, parents of Eckhart and Tinker. They decided to express their opposition to the war in Vietnam. Don't know what the background story is behind it. Maybe they had a brother or a family member that got shipped out. And they were just peacefully objecting by wearing black armbands between December and fasting between December 16th, 1965 and New Year's Day of that following year, so 1966. So it was during the Christmas break, I guess you'd say, the holiday season I do not know what school days were in session for these or which, but they obviously went to school on the 16th and 17th, were suspended until they either stopped wearing the armbands or, whatever. The principals enacted a policy 2 days previously on December 14th because they heard it, talk got around, they heard that they were going to do this and wear these armbands. However, there was no fights, no picketing. It was 3 students that wore it. There was no, no violence committed. It was very peaceful. They just wore the armbands to school. So when it made it to court, in the district court, they dismissed it on the grounds that it disturbed the environment. So that's, I don't know if we've gotten into this yet, but back to the O'Brien test, does it, I guess that really doesn't say. Is it an important governmental interest? I mean, I think so. The country was at war, but at the same time, it didn't really go there with that. It goes to obviously Tinker appeals. They go to the 8th Circuit Appellate Court, and then on the bench, and bonk, the judges are equally divided, so they're both split. They have 2 that say, I affirm what the district court says. They have 2 that say, I dissented. So they were granted the request to go to the Supreme Court, and then the Supreme Court reversed and remanded it, saying, this is actually a very popular quote from this case, that teachers and students do not shed their rights at the schoolhouse gate. You don't go into a school and then all your rights are, left, behind. You have to still respect a student's right even in school. And even though school is a unique setting and you do have to think about the rights of others, we still have to respect the rights of the students. So they said that the students were within their rights of pure speech and it was separate from disruptive content. They didn't cause a problem. And then I had an interesting little sub-note from the case. It says, the classroom is peculiarly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. So I liked that in saying that our country is kind of founded upon, having your own voice. It shouldn't be stifled. And unfortunately, in some cases, you can't just go and say, oh, you can't say that and stuff because, that's why all these laws were put in place and all these amendments were written. So our next case is Bethel versus School District number 403 and versus Fraser in Washington State. This is not about a dress code, but it set a lot of precedent and all of that it involved. During a school election, a peer was nominating his friend, and he uses very elaborate, graphic, and explicit sexual metaphors. So he had mentioned priorly to 2 other teachers a couple days before the speech, whatever the assembly, I'm going to give the speech and this is what I'm going to say. And the teacher said, well, that's inappropriate and you're going to be suspended or you're going to have consequences for it. After he gave the speech, he was suspended for originally 3 days, but they only made him serve 2 and they allowed him to come back on the 3rd day. And then he was also removed from the graduation speaker list. What do you guys think the issue would be here about the speech being explicit in a school? Is that ringing? Why would it be unconstitutional, or why would this person lose their right?
There may be a school policy against what kind of speech they may use.
Right, very good. Okay, that's going to be one of the points in the next slide. Okay, so in the district court, I was actually shocked. They found in favor of the student, awarded him damages, and gave him injunctive relief saying you're no longer suspended from the list of you can speak at graduation. He ended up speaking at graduation, and then, of course, the school appealed. The appellate 9th Circuit Court affirmed the district court's decision, and then it was obviously the certiorari certiorari was given, and then they made it to the U.S. Supreme Court. This is where they reversed it. They said it's inconsistent with fundamental values as the speech did not address political issues. It had nothing to do with, America's laws, or it was inside the school. The school acts as the instrument of the state. So if they were told that you can no longer side in your own school what's a lewd and vulgar content or act or speech, then an educational mission would then be negated. So they're saying if they would have ruled in favor of the student, they're saying, well, the school then just has no control over where to draw the line in that matter. There was no violation of due process, and he had adequate warning of, hey, you're going to get suspended if you give that speech. So there was he couldn't claim, oh, them penalizing me by suspending me was unfair or unconstitutional. And then last case, Barr versus LaFawn and Blount County School Board in Tennessee, actually just recently, 2 years ago. This school would have been having a lot of problems with fights between black and white students, threats written on the bathroom stalls in graffiti, with hit lists. I'm going to come kill this person. Got into a fight at a basketball game. A parent made a complaint that the African American student that got suspended, it was unfair because the white student didn't get suspended at all. And then other kind of threats led to a police lockdown. So it got very serious for, I believe it was the spring of 2006. For a while, there was nobody coming to school because they're all scared, and there's a lot of racial tension going on. Previously, the school had already strictly enforced and reiterated their dress code every year to their students. They said, we do not want any kind of racially divisive symbols on your dress or on your clothing. So they didn't say, we don't want stuff that says bad things about black people. We didn't say we don't want stuff that says bad things about white people. It was very general, or very specific in the fact of what they didn't want, but very neutral. So the following school year, 23 out of 452 documented dress code violations at the beginning of that year included Confederate flags. So the issue here is they said they're just wearing it to represent their Southern heritage. I don't know if they were new students or what, but they did it, they knew the code, they did it anyways, and they were suspended. And then they claimed the three that we talked about at the beginning, your First Amendment, your due process, and your equal protection clauses. So in the district court, they granted the school board and the principal's summary judgment with prejudice to the Blount County School Board. They stated,
everybody?
Can't bring it back. Can't bring it back.
the images of the rebel flag obviously disrupted the school atmosphere. It wasn't just necessarily of, well, this doesn't, they couldn't say the Confederate flag. This doesn't mean, I'm not trying to be derogatory toward anyone. It was already having a problem. They were already causing or having issues with fights and gun threats and other kinds of death threats already. So it was definitely disrupting the atmosphere of the school. The code was narrowly tailored to a substantial government interest. So I think it was kind of not humorous, but that the 14th Amendment is a big issue in this case, and it's coming, it's all coming full circle with the Civil War and the Confederate flag and stuff. It was an issue because it had to do with the United States at one point. I guess that's what I'm trying to say. And then they also couldn't prove the due process claim because they had such a strict school code that everybody knew about. And then once it appealed in the Sixth Circuit, they affirmed the decision of the district court and denied the certiorari. All right, so what we need to remember, or I guess I'm going to ask you guys, and you tell me yes or no, and then explain how it would be constitutional if you answered yes or no to this question. So does the dress code materially and substantially interfere with appropriate discipline, the rights of others, and the operation of the educational environment? If the answer was yes, what would be the ruling? What would be your decision on would it hold up in court? Would the dress code hold up in court? If it interferes with the rights of others, appropriate discipline, and operation of a school atmosphere. It would. If it did interfere with the rights of others? Okay. Does the dress code interfere with the rights of others? No. Okay, good. Sorry, that was kind of difficult. I'm just trying to make you guys think. All right. Does the dress code apply to the rights of the students in light of special characteristics of the school environment? If it supports the rights of the students, is it constitutional? Okay. Does it attempt to avoid a controversial or unpopular opinion? No. Okay.
Maybe
the reason
if the dress code, maybe that's
okay. If the dress code attempts to avoid generally, just they heard about something, I'm just trying to avoid this controversy.
Like the armbands.
Like the armbands.
So that didn't hold up, right?
Right.
So no.
No. Okay, good. If the dress code remained consistent with fundamental values, is it constitutional?
Yes.
And is the dress code, if the dress code is related to a substantial government or political viewpoint and causing an issue about that, would it hold up? No, because you're getting into problems with the United States federal problems. All right, over to Anna.
Okay, so now as far as grooming codes, this was another just example that I found online of a grooming code at an elementary school. It didn't specify whether this was girls or boys, so I guess this goes for both sexes. But we'll see lots of these things in the cases. Not being excessively full, that makes me just think of hairspray, like Tracy Turnblad. Designs are not permitted. We didn't include this case, but we saw in our research a case of a boy with certain hair braids, so maybe something like that. Untrimmed sideburns, we'll see extreme hairdos that would be disruptive. It's like a mohawk. No tufts or tails, and then hair combed forward that's in your eyes, which we touched on in one of the dress codes. Okay, a background of the culture. Lots of these issues were raised in the 60s and 70s, where people like the Beatles had popularized styles that were not conducive to these grooming codes in the schools. So just kind of a background of knowing that that was the era is important when you're thinking about these different grooming codes. Okay, the first one is Carr versus Schmidt. It was in Texas in 1972. This is Chesley Carr. I was able to find a picture of him. He was a 16-year-old male. He had worked all summer on a farm in the Midwest. He attempted to enroll for his junior year at Coronado High School in El Paso, Texas, but was not permitted to do so since he was in violation with the grooming code. His hair is over his ears, it's down close to his face, and it's over his collar. But does that look like a lot of our students in school today? Beaver hair? Okay. So Carr let his hair grow over his ears and collar because haircuts had not been a high priority when he was working on the farm. Getting a haircut wasn't on the top of the to-do list. So I thought this was interesting too. He referred to his long hair as a freak flag and believed that it identified him as a supporter of the hippie movement. So he was doing this in a way of symbolizing his support of that movement. Regardless, the school didn't care. They refused him in minutes and so Carr took the school to federal court. This was the code. Does this look familiar to one of the groups? Yeah, that was the code that Lindsay and them had. I thought what was really interesting was the beginning. The matter of student grooming is of utmost concern to parents who realize the importance of seeing that children are properly attired when they leave for school each day. It goes on to say, schools also recognize that parents are basically responsible for their children's dress and general appearance. The role of the school is one of guidance for pupils in an effort for total education and the development of proper attitudes. So that's kind of important in their mission or their rationale for this code, is that they just want a healthy learning environment. They don't want anyone to be distracted. And then Lindsay read these earlier. So you want to go over those again. Okay. At the federal court, they granted Carr's injunctive and declaratory relief. They said that Chesley must be enrolled in school and that they couldn't enforce that dress code anymore. The school principals sought further review, so it went to the Court of Appeals, who reversed and dismissed the case. Basically, they decided that the freedom there's no constitutional right to wear one's hair in a public high school in the length and style suited to the wearer. So they're saying your right to wear your hair as you'd like to is not a fundamental one. It's not constitutional. So the dress code as it was could stand. It itself was constitutional. So moving on.
Can I just interject something?
Sure.
I don't know if any of you read your reading assignment, but if you looked at it, it said that the courts are going to deal with when you're taking someone's right away. Is it a fundamental right or is it a non-fundamental right? And fundamental rights certainly are just those things that are more important. Your freedom of speech, your freedom of religion, etc. Is hair length important enough to be considered in that category? Most of them are saying, at least in that case that we saw, no.
Okay. The next was Dunham versus Pulsifer. It was at the same time, 1970-ish, in Vermont. Okay, this was actually 3 different boys: Steve Dunham, Prentice Smith, and Paul Weber. They were all tennis players for the high school tennis team, and then they all had various accolades. Steve was a senior who was ranked 8th in his class. Prentice was a senior. He was a member of the student council. He was class president. And then the third one, Paul, was a junior and was ranked 10th in his class. So they were all very academically sound. They were well-rounded. They were 1, 2, and 3 on the tennis team, so they were very skilled in tennis as well. So no discipline problems. They weren't acting out, anything like that. On April 16th, the young men were prevented from participating in a tennis match due to their failure to comply with the grooming code for extra class scholastic activities. This one, which group? Remember? Yeah, y'all had that one. So it was a dress code and a grooming code for the athletics. Okay, so the students sought an injunction against the superintendent to bar the enforcement of the school's athletic grooming code. They claimed that the code deprived them of their 14th Amendment right to equal protection of the law. So that was, like Katie was saying, obviously it wasn't a racial thing, but it was more of them being classified in a certain group and they were being treated differently than other students in the school. The court agreed with them. They said evidence failed to show that the code was necessary in some compelling governmental interest that was the duty of the school authorities to protect or enforce. Okay, so like Dr. Roberts was saying, does that phrase, necessary in some compelling governmental interest, sound familiar from last night's reading? They're referring to that. Does that go for a fundamental or a non-fundamental right?
To be a compelling governmental interest.
Okay, that's a fundamental right. Okay, so.
Okay, but go one further than that. For what reason would the schools say that we have a compelling interest to make hair length be limited?
It's causing crimes around the school or something like that?
Causing
problems?
Maybe, if there's disruptions, but if we're talking about athletics, if the hair length is such that it causes some kind of safety problem, would that be? Is safety a compelling governmental interest? Yeah. Okay, safety certainly would be. Okay, go on.
And so the code was deemed unconstitutional. The players said that if their hair was too long, they could wear a headband easily to keep it out of their eyes. They had no discipline issues. It wasn't affecting their teamwork. And so the code was deemed unconstitutional. Okay, so that was opposite of what was said in the Carr case. The last one, Barber versus the Colorado Independent School District. This was more recent. This was in 1994 in Texas. Austin Barber was an 18-year-old high school senior in Colorado City, Texas, and he filed a class action suit challenging the legality under the state constitution of hair length and earring restrictions imposed upon male high school students. Nobody had this dress and grooming code. What was given was very small, so we didn't elaborate on that. But he felt that the school board should not be able to dictate to an adult student matters of hairstyle. So he thought the fact that he was 18 was very important in this case. Additionally, he remarked that he would like to be free from sexual discrimination. So he's also adding that the fact that girls can have longer hair and girls can wear earrings is not fair, since boys cannot. Okay. The grooming code stated that boys may wear hair to the bottom of the collar, the bottom of the ear, and come out of the eyes. Boys may not wear earrings of any kind. So the grooming part is very similar to the other grooming codes that we visited, but the earring is kind of new. It also claimed that its purpose was to teach grooming and hygiene, instill discipline, prevent disruption, avoid safety hazards, and teach respect for authority. I think the most important in that is preventing disruption so that you have a good learning environment, and then avoiding the safety hazards. Obviously, we know that in sports and in PE, wearing earrings could be dangerous if someone was to hit you in the ear, and it could pierce your neck or something like that. So, all right. When it went to trial, the trial court rendered judgment solely on the Equal Rights Amendment. They ruled that the grooming code violated the state constitution, and they granted permanent injunction against the defendant, so saying that those rules could no longer be enforced against him. The school district appealed. In the appellate court, the court reversed the trial court decision. They said that Barber's claims do not manifest such an affront to his constitutional rights as to merit our intervention in this case. So this is going back to kind of the Carr findings, in that hair length is not a constitutional right. It's not a fundamental right, so the constitutionality is not in question. Barber was not satisfied with this decision, so he appealed it to the state Supreme Court, so the Texas Supreme Court. There they found that while minors do have constitutional rights, they're not the same as adults. The main reasons were the vulnerability of children, their inability to make informed decisions in a mature manner, and the importance of a parental role in child rearing. So the state decided that schools in the state, or schools as the state's agent, have more control over the conduct of minors than they do over adults. So they affirmed what the appellate court said and ruled that that dress code was constitutional, and it was upheld. Okay. So just in summary, most of the courts agreed that it's a matter of common sense that the state judiciary is less competent to deal with the student's hair length than a parent, school board, administrator, principal, or teacher. So they're pretty much saying that it's not a constitutional right. It shouldn't come to the seat of the judge. It should be decided among school personnel. Also, what was brought up in a lot of the cases is that grooming is a lot different than dress. If you're not allowed to wear a certain t-shirt that you like at school, you can put that on when you get home. If you can't wear your hair like you'd like to, that's the same at school and at home. It's much more of a permanent change. So it's still somewhat debatable whether or not this is a fundamental and constitutional right, but it is a lot different than grooming in that permanent nature. So in constructing a grooming code, I just went back to obviously what a reasonable and prudent, up-to-date teacher would do. So I just said you should be reasonable and prudent when constructing such policies. I don't know, obviously I'm not in the school systems now. Robin or Lindsay, do you know if y'all's school has a grooming policy? It doesn't seem like it, just the way that kids are wearing their hair nowadays. But obviously in PE, we would want, like Amanda said, it would be a safety thing. If there was an issue with it being in their eyes where they couldn't see to participate, or wearing jewelry, that would be important. And we have one other.
If something ever goes to court, if you've created a policy that affects their attire, affects their grooming, etc., have a good reason for it, justify it well. Because if it's related to the health of the student, to the safety of the student, to preventing disruptive behavior among students, Sometimes they're okay with it promoting better discipline or even better sportsmanship and team spirit. But the stronger you can make your case for having a rule, the better off you are. Because that's what courts are looking at. Why is this rule necessary? Okay. Go ahead.
Okay. So we have one more case that's strictly applicable to, or more applicable to physical education. All right, we found, so just so you guys have kind of a, in our own setting, relation. This PE teacher allowed his student to participate barefoot because he didn't have the proper shoes to participate in the first place. So he said, take your shoes off and you can go participate then. Well, obviously, little William tripped, fell, and hurt his feet. And the parents, of course, are going to be plaintiffs in this case on a negligence. And would anyone like to raise their hand and tell me what duty the teacher, physical education teacher, failed to? Yvette?
Proper instruction.
Proper instruction. Okay, you said it's okay if you don't wear your shoes, right? Anything else? Liz? Proper equipment. Okay, you have to have tennis shoes and PE class. Very good.
Which is related to the duty to provide
safe
environment.
Thank you, Dr. Roberts. All right. And do you think, being in this class after all the cases we've heard, do you think this is a foreseeable risk to let someone go run barefoot? Okay, great. Okay, so our next activity, we want you to get back in the groups that you were in earlier. Katie's going to bring around these little grab bags. You can open them. In them are different hairstyles and pieces of attire. I want you to go through and pick out, sort which ones you think would be acceptable and unacceptable in the schools, and then be prepared to explain why, based on what you've learned so far. Katie and I will circulate if you have questions on what something actually is.
I would say acceptable.
What do you think? What are we saying?
It's kind of
Yeah. Scruffy. Okay, you guys did good. Very good. Crazy questions about what anything is. What do you guys think? But does that have a vulgar connotation? Those are just a couple reasons. So what do you think is appropriate? Well, it's not, everyone doesn't have an outfit. What about those sideburns? I don't know. You like them? Oh. Do you have any questions? And the piercings, the ear piercing? What about Ugg boots? They say they're not safe? No. No.
But his hair is in his eyes.
His eyes are still peeping out.
Oh yeah, if Robin, if you're in PE. Yeah. Yeah, okay. Yeah, you could explain it whether we're in PE. What do you guys think?
It looks like his eyes.
Is that your appropriate and inappropriate? Right.
So I say this is covered.
What about if we were in PE? Ugg boots. Okay. No, I'm just asking in general, and then we'll say. Okay, is everybody kind of ready to present? This group had a good question. Is this for a general dress code or specific to PE? Let's address it first generally, and then you can tell me if you have any differences if you were in the PE environment. So we'll start with your group.
These are unacceptable.
Kind of hold them up.
Well, it's the t-shirt that says drugs suck. And then,
Okay, why is drugs suck not appropriate?
The word.
Right, and the connotation.
okay, the rebel flag. And we thought this skirt was too short.
Okay, very good.
Generally acceptable. We found this guy's earring generally acceptable, along with his facial hair, his sideburns, and long goatee. Pants. These pants, capris, they're great. Uggs.
We wish they were out, but they're
that's
not.
fine. So that was what we thought for a general setting.
But in PE, the Uggs would not be acceptable, nor would the earring.
And I would say maybe the hair. If he can't see, then it is probably
We just
a
want
safety
to go
hazard.
through
but-
Talking about the other guy?
Yeah, this guy. I don't know if he can see or not. So. Okay. Andrea, what about your group?
Acceptable. Even though I don't like the logo. Acceptable. Beaver hair. Beaver hair. Acceptable. Questionable.
He has a
Scruffy face.
Yeah. And then we got the chains on the pants were unacceptable. This mohawk guy and the
Grocery bag shirt.
grocery bag shirt.
Midriff. Yeah.
Okay, you're good.
We had cut off jeans, unacceptable. Swastika shirt, unacceptable. Smoking blows, unacceptable. We said pink-haired lady, that's unacceptable. We had beaver hair is acceptable. And regular old pants, khaki. And then Uggs, but not acceptable in PE.
Right. Okay, so this is pretty much.
I don't agree with all of those.
Which
Pink
ones?
hair, like, like Jay has pink hair.
Yeah, we.
She also has a nose
But
ring.
it's not this high. It's not that
But
big.
can you tell a kid not what color their hair? Like, what about redheaded kid had that bright orange red hair?
But you can change that.
But
I mean,
Well, I know, but I'm saying.
to me, telling them that they can't cut their hair is something they can change. Definitely dyeing it hot pink is, to me, would be disturbing in a classroom.
But that can change more quickly than the length of somebody's hair can change.
I know, so then they don't have to.
I think they have the right to have whatever color hair they want to. Who's to say that blonde hair and brown and brunette are the only three colors? I mean, blonde, brunette, and redhead are the only three.
And you have to
I think that's just really red.
Because I go platinum blonde sometimes, and people may think that's disturbing, but I don't care. That's
So,
all there.
so if a girl wore bright pink hair, was told she needed to change it, refused, they expelled her. She took it to court. What are the courts going to be looking at in making a decision?
Is it safety concern?
Okay, what is the reason for the rule that says you can't have pink hair? What's the basis for making that rule?
Distracting.
Okay.
Making it to the learning environment is what I would think.
I would say
That would look
I guarantee if one of us came up in this room with pink bright hair,
I'd look
everybody
at
would
it
go.
and I'd say, you
would
know what,
get
there's
it.
space, and then I'd burn me over it.
That's distracting. They don't want people.
But in younger kids, I feel like younger kids.
You have black hair.
And one of the things that's true is we don't know for sure what the courts would say, so we have to sit down around the table if we're a school board or somebody developing a policy and discuss it, including what experiences we've had with different hair colors in the past and whether it influenced behavior or whether it turned out to be a non-issue. Because they will be looking at that. Has this caused problems in the school before? What's the history here? Okay, but we maybe won't know the answer to this question until the courts have such a case.
Right, because obviously the grooming cases that we looked at had mixed opinions. Some upheld it and some did not, so it's hard to know. All right, so all we have left are kind of recommendations. First of all, we said rules and regulations should be established to enhance a positive learning environment. That's what we were just talking. It shouldn't be. No student's hair or dress should be distracting to the others.
Positive and safe. I would just add. There we go. We're gonna.
I want to write it.
Oh,
no. What the heck?
But again, because it goes back to the reason and safety is compelling interest of the schools, that's why I emphasize that one.
Okay. Also, like the last case said, the Barber case, since minors have different constitutional rights, the school represents a unique setting. So a quote that we really liked was that you need to secure individual rights without infringing on the rights of others. So that's an important quotation to remember. Sure.
And that goes back to the free speech where the kid was giving sexually explicit speech. in the fact that there are still minors in your audience, and you don't send your kids to school to have just whoever talk about whatever, and it obviously made a lot of the students uncomfortable when he was saying those things. So that's another issue of school as a unique environment. Like we were saying, a lot of it today, compared to the 1970s, like with the hair, has changed a lot. We see little kids running around all the time today with longer hair, like boys with longer hair now. So just be prudent and reasonable and seek a compromise before you start, and always let them know what the code is or what the rules are before you start. We do need to make exceptions for religious practices. Obviously, people have headdresses or the different garb that they wear. So have exceptions for that in your code, and then always be reasonable and narrowly define your reasoning behind a certain rule or code or banning, like they said about the racially divisive clothing. This is the main point to remember throughout all of it. Have freedom without disruption. So. And here's just for you guys' records to keep, just like a brief overview of our presentation and the high points that you need to remember when referring to dress and grooming codes.
All right, let me ask one follow-up question here. The landmark case in this was the Tinker versus Des Moines, which is the armband case. And in that case, you heard the statement, teachers and students don't shed their constitutional right to freedom of speech and expression at the schoolhouse gate. And that may be a surprising thing to go back and read, given the fact that in schools now, we're seeing all kinds of things you can't wear on your T-shirts, or headbands, or all kinds of things, all kinds of emblems, etc. What's the rationale for restricting that freedom as much as we are in modern times? Why couldn't they wear a swastika? Why couldn't they wear a gang-related symbol? Why couldn't they wear... Okay. This whole thing about it causing disturbances, and that's not just disrupting learning, that becomes a safety issue also, doesn't it? So the prevalence of gangs in particular areas of the country, and in urban areas, urban areas in particular, not rural, urban areas in particular, where there's high gang activity, you're going to find more schools with more rules prohibiting what students can wear, because they're looking at the history of activity in those areas. So, all right, Thursday we will be back here again for Manjack. Or pardon?
For Manjack.
For lesson on drug testing. And then we'll continue with some of our other presentations.
Which we left out hours on purpose. It was,
You left out what?
Drug test and bar search.
We didn't mention it. Drug testing is a part of search and seizure. Which you know if you read your homework. Thank you. That's why I was letting them read it.
I said, yes, we have to have water.